Blackmail is an act of coercion using the threat of revealing or publicizing either substantially true or false information about a person or people unless certain demands are met. It is often damaging information and may be revealed to family members or associates rather than to the general public. It may involve using threats of physical, mental or emotional harm, or of criminal prosecution, against the victim or someone close to the victim. It is normally carried out for personal gain, most commonly of position, money, or property. It is also used, sometimes by state agencies, to exert influence. This was a common Soviet practice, so much so that the term, kompromat, transliterated from Russian, is often used for compromising material used to exert control. Blackmail may also be considered a form of extortion. Although the two are generally synonymous, extortion is the taking of personal property by threat of future harm. Blackmail is the use of threat to prevent another from engaging in a lawful occupation in writing libelous letters or letters that provoke a breach of the peace, as well as use of intimidation for purposes of collecting an unpaid debt. In many jurisdictions, blackmail is a statutory offense, often criminal, carrying punitive sanctions for convicted perpetrators. Blackmail is the name of a statutory offense in the United States, England and Wales, and Australia, and has been used as a convenient way of referring to certain other offences, but was not a term used in English law until 1968. Blackmail was originally a term from the Scottish borders meaning payments rendered in exchange for protection from thieves and marauders. The mail part of blackmail derives from Middle English mail meaning rent or tribute. This tribute was paid in goods or labor, hence redditus nigri, or blackmail. Alternatively, it may be derived from two Scottish Gaelic words blathich to protect, and mal tribute or payment. The word blackmail is variously derived from the word for tribute. An alternative version is that rents in the Scottish borders were often paid in produce of the land, called green mail and mal, cf. buttock mail. He notes that the practice was common in the Scottish Highlands as well as the borders. In the Irish language, the term ceos dubh, meaning black rent, has also been employed. The offence of blackmail is created by Section 87 of the Crimes Act 1958. Sections 87 and of the Theft Act 1968 printed above. Section 87 provides that a person guilty of blackmail is guilty of an indictable offence and liable to level 4 imprisonment. The offence of blackmail is created by Part 6b Section 172 of the Criminal Law Consolidation Act 1935. Section 172 provides that a person who menaces another intending to get the other to submit to a demand is guilty of blackmail and may be subject to imprisonment. The offence created by Section 17 of the Criminal Justice Act 1994 is described by the marginal note to that section as blackmail, extortion and demanding money with menaces. The offence is derived from the offence under Section 21 of the Theft Act 1968. In England and Wales, this offence is created by Section 21 of that Act provide. A person is guilty of blackmail if, with a view to gain for himself or another or with intent to cause loss to another, he makes any unwarranted demand with menaces. And for this purpose, a demand with menaces is unwarranted unless the person making it does so in the belief the nature of the act or omission demanded is immaterial, and it is also immaterial whether the menaces relate to action to be taken by the person making the demand. The Theft Act 1968 Section 21 contains the present-day definition of blackmail in English law. It requires 4 elements. Therefore, the requirement for this offence may be paraphrased as, the law considers a demand with menaces to always be unwarranted, unless the perpetrator actually believed that her demand had reasonable grounds, and also actually believed that the menace was a proper way to reinforce that demand. These tests relate to the actual belief of the perpetrator, not the belief of an ordinary or reasonable person. Therefore, tests related to what a reasonable person might think, and tests of dishonesty, are not often relevant. The matter hinges upon the actual and honest beliefs and knowledge of the perpetrator herself. The wording of the Act means that there is a presumption in law that demands and/or menaces are likely to be deemed unwarranted, unless the perpetrator shows evidence that they were believed not to be. However, once a perpetrator has defended herself by giving evidence related to the demand and menace, both being believed warranted, the prosecution must overturn one or both of these claims to prove their case. The usual rule is that a criminal act, or a belief not truly held, can never be warranted, although according to some authors, a gray area may exist where a very